On November 22, 2025, Christopher Hobbs was issued a civil parking citation for parking in a prohibited no parking zone and blocking a residential driveway on Bettis Boulevard in Rollingwood, Texas. The citation arose from an enforcement action conducted by Corporal Aaron Bruns of the Rollingwood Police Department. Following the incident on December 3, 2025, Mr. Hobbs filed an original petition pursuant to Section 2308.452 of the Texas Occupations Code, effectively entering a request to challenge the enforcement action and revoke the citation's justification for the subsequent tow. The case was heard in the Travis County Justice of the Peace Court before Judge Sylvia Holmes. Mr. Hobbs appeared representing himself, and as the moving party who initiated the statutory action, he opened the evidentiary hearing by testifying.
Christopher Hobbs?
Yes, I'm here, Your Honor.
Good afternoon, Mr. Hobbs. And do I have someone on behalf of the Rollingwood Police Department?
Yes, ma'am. How are you doing, Judge?
I'm just fine. And Mr. Jones, are you a member of the police department? Are you counsel?
No, I'm an attorney for Rollingwood.
Okay. Good afternoon. All right. Mr. Hobbs, tell me what happened. What day was your vehicle towed?
The vehicle was towed on, sorry, 1 second. I have it up here.
November 22nd.
The vehicle was towed on November 22nd.
Where was it at?
Bettis Boulevard in Rollingwood.
So public street?
Yes, ma'am.
Were you present when the car was towed, or did you come back and discover it later?
When the police had arrived, we were taking a walk, and then we showed up and the police were there, but the tow truck driver had not arrived yet.
So I'll say again, were you present to witness your car towed away, or did you come
Yes,
back
ma'am.
and discover it had been towed?
I was there present watching it get towed.
Where had your car been parked?
My car had been parked on the side street, unfortunately in a no parking zone and blocking a public driveway.
So the reason it was getting towed is not a confusion.
No, ma'am.
All right. Why'd you park in no parking zone?
It was ignorance. We did not notice.
I think you just said it was labeled no parking.
It was recently labeled as a no parking zone. We'd been parking there for, about
Who are
12
you and
years.
why are
as
you
long as
talking?
we lived here.
Sir, who
I'm
are
a
you?
witness. I was there.
All right, but it's Mr. Hobbs' case, right?
Yeah.
Who actually parked the car that day?
Me.
Right, and when you parked it, did you look around before you parked to see if there was signs that indicated you could park there?
No, ma'am. We had been parking there for about 12 years and it was only recently labeled a no parking zone. So
Was it labeled no parking the day on November 22nd when you got towed?
Yes, ma'am, it was.
And so you did not observe those signs that day?
No, we did not.
So it was different than all the times previously, you didn't observe that?
Yes, ma'am.
Okay. When you came back and saw your car getting towed, did you then observe those signs?
Yes, they were pointed out to us by Rollingwood PD.
Okay. Why do you believe your car was improperly towed if you then discovered there was a no parking zone?
We were not given a opportunity to move the car or given an opportunity to get a drop fee, which we requested both.
All right, so you arrived, you parked, you left, you came back. When you came back, your car was getting towed?
My car was getting ticketed at the time. The tow truck driver had not arrived.
All right. How long after you arrived and you got the ticket did the tow driver arrive?
10-ish minutes, 10, 15 minutes.
I'm just curious. Did you try to leave? Did you ask to leave? Why didn't you
We
leave?
did ask to leave and we were told no by Rollingwood PD.
Do you recognize the person in the courtroom today who told you not to leave?
No, I do not.
Is that person present?
No.
Did they tell you why you couldn't leave?
It was getting towed and it was too late.
But the tow truck driver had not arrived?
No, they had not.
Mr. Hobbs acknowledges that his vehicle was parked in a restricted zone under Texas Transportation Code 545.302. Specifically, B1 prohibits standing or parking an occupied or unoccupied vehicle in front of a public or private driveway, and 2 applies to the prohibition of parking where an official sign restricts it. However, according to regulatory standards enforced by the Texas Department of Licensing and Regulation, if a vehicle owner or operator returns to their vehicle before it is fully prepared and hooked up for transport, they are entitled to reclaim and move their vehicle without paying any towing charges. Furthermore, under 16 Texas Administrative Code 86.455C, if an operator attempts to retrieve a light duty vehicle after hookup but before its physical removal from the property, the maximum drop charge is strictly capped by state law at $135. Because the primary legal purpose of a non-consent tow is to clear a public hazard or obstruction, a driver's physical presence and willingness to move the car completely eliminates the administrative necessity of a governmental impoundment. While the officer retains the lawful authority to issue a standard parking citation for the violation, they should not block a driver from clearing the obstruction themselves. Because Mr. Hobbs arrived before the vehicle was hooked up or removed, he should have been allowed to clear the zone immediately, limiting his liability to the standard $135 local parking citation.
So do you have any information
Judge,
as to whether the tow truck driver had arrived and already had the car up?
right. Judge, I'd like to call Corporal Aaron Bruns. He should be here. Do you see him? Corporal Bruns?
Yes, Mr. Bruns, Corporal Bruns, are you with us?
Yes, ma'am.
All right, good afternoon, sir. Were you here to be sworn in?
Yes, ma'am.
All right, I understand you're under oath. Go ahead, Mr. Jones.
All right. Corporal Bruns, could you please tell the court what happened that day? Start from the beginning and tell us what happened.
We received a call about a vehicle blocking a resident's driveway.
Sure,
So-
he was parked wrong. I got it.
Yes, ma'am. So I went to that resident and spoke with them and asked them if that was their car. They said no, because they were not able to access their driveway.
Yeah.
Asked them if they would like the car towed. They said yes. I then instructed an officer with me to impound that vehicle. ATEX towing was called. They came to impound the vehicle.
Right. Are you the one who spoke to the plaintiff?
Yes, ma'am.
Is it correct the plaintiff says that he swore under oath that you told him he could not leave the car after it was ticketed?
He could not leave. He could not leave the car.
Yeah, no, he wanted to drive away with the vehicle. He says that you told him he had to stay and get towed.
No, I did not say that to him.
Do you recall if you told him he couldn't drive his vehicle away?
What I recall is after the tow truck had arrived.
Before the tow truck arrived. He
Right.
says, Mr. Hobbs just testified that he came back from walking away. He discovered that there was a car that he was being ticketed. That he took the ticket and then he tried to
Right.
leave and the officer told him you can't leave. Are you that officer?
I am the officer he spoke with. I do not recall me telling him that he could not leave.
Mr. Hobbs, this is a very important part of your case. You said
Yes,
you didn't
ma'am.
recognize this person. Is Corporal Bruns the person you spoke to that day?
Yes, Your Honor. I didn't recognize him. He wasn't up on the Zoom screen on the side, so I couldn't see him.
All right, and Mr. Hobbs, is it your testimony that Corporal Bruns told you you could not leave, you could not drive away your vehicle and avoid being towed?
Yes, we asked if we could, and we were told no.
Corporal Bruns, how would you respond? He says that you told him he could not remove his vehicle and leave.
I'm confused. This is prior to the vehicle prior to the tow company arriving. As I recall, nobody asked to leave the area at that time. I did
Corporal
explain
Bruns?
that it was being towed.
Corporal Bruns stated that he did not recall Mr. Hobbs asking to move the vehicle. However, the primary legislative intent of Texas Transportation Code, Section 545.305, is to clear hazardous or disruptive parking violations efficiently. Because the statute explicitly authorizes an officer to require the operator to move a vehicle, the statutory purpose is fully realized the moment a driver returns and volunteers to clear the obstruction immediately. If Corporal Bruns actively ordered Mr. Hobbs to remain in place and forced him to wait for a tow truck to arrive, the officer's actions directly contradicted the legislative intent of Texas Transportation Code and constituted an abuse of authority. Specifically, by utilizing police power to intentionally subvert state-protected citizen rights, such conduct implicates Texas Penal Code 39.03, which prohibits a public servant from knowingly denying or impeding a citizen in the exercise or enjoyment of any legal right or privilege. Forcing a driver to remain stationary solely to engineer an unnecessary towing situation effectively denies them their statutory right to discontinue a non-consent tow before hookup occurs, which is strictly protected under Chapter 2308 of the Texas Occupations Code. Accordingly, this line of questioning by Judge Holmes appeared to be an attempt to analyze both the lawfulness of the tow that set the impoundment in motion and the validity of Corporal Bruntz's directive to detain the vehicle once Mr. Hobbs's attempt to drive away was underway.
Y'all, let's get our timeline down. Corporal Bruns,
Okay.
is it accurate that you had a conversation or at least met the defendant, the plaintiff today, Mr. Hobbs, prior to the tow truck arriving?
Yes.
And you gave him a ticket prior to the tow truck arriving?
A ticket was issued while it was unattended.
Sure. Okay, so he got a ticket. Why didn't he get in his car and drive away? Why did the tow truck need to show up and tow him when you literally had the driver who could remove the vehicle and stop the problem right then and there?
I had already contacted the tow company.
I don't care. That's not the law. Why not let him get in his car and drive it away?
My understanding is that a vehicle can be towed for blocking the driveway.
100% it can. You were right to call the tow truck. The law
Right.
says though that once the driver's returned, tow truck shouldn't be involved. Even if he'd shown up and the tow truck was lifting it up, he has the right to pay a drop fee and get his truck and not have to deal with the impounding of it. So my question is, if you're there, he's got a ticket, the situation can be averted. Why was he towed?
Yes, if I can explain that. My understanding is that the drop fee is in reference to, and those rights are associated with private property towing, not from a public street initiated by a police officer. And our towing, is my understanding, was governed by our contract with ATEX Towing, and my discretion. So the vehicle was impounded according to those rules.
All right. I don't find that to be true, sir. Corporal
Okay.
Bruns, I'm glad you helped out that homeowner. Certainly, Mr. Hobbs, pay more attention where you're parking. I find it hard to believe you didn't realize you were blocking a driveway in Rollingwood. Okay? Pay attention. There's nothing worse than having people block my driveway. But at the
Yes,
same
Your Honor.
time, he was there to move his car. He shouldn't have been towed. Judgment for the plaintiff. How much did you pay to get your car to tow, Mr. Hobbs?
$436.76.
All right, judgment for the plaintiff, 436.77. Again, tow, he should have been towed, but since he showed up before the tow truck arrived, there's no difference. I don't see any distinction in the law between the public and the private street. Driver was there, whole thing could have been averted, right? All right, all parties can appeal that decision if you want, otherwise judgment for the plaintiff. All parties are excused. Y'all have a good afternoon.
Judge Holmes concluded as a matter of law that the Rollingwood Police Department lacked probable cause for the removal and storage of the vehicle. Under the statutory framework governing non-consent towing in Texas, which explicitly enforces state administrative rules via Texas Occupations Code, Section 2308.458, and defines a lack of probable cause. A public impoundment is legally unjustified if the operator returns to the scene and is physically present to clear the vehicle before mechanical hookup procedures are finalized. Because Mr. Hobbs was present and ready to eliminate the obstruction, the necessity for a non-consent tow was entirely dissolved. Consequently, the court entered a final judgment sustaining Mr. Hobbs's statutory objection and awarding him $436.76 in damages against the Rollingwood Police Department. Our next case occurred on May 2nd, 2024. Driver Anton Conley drove a dark-colored Dodge Challenger through a residential neighborhood in Taylor, Michigan, while fleeing from the Detroit Police Department. Guided by an airborne police helicopter, Trooper Cody Longuski of the Michigan State Police responded to the high-speed pursuit along Kenyon and Statler Street, along with two other troopers. While attempting to execute a traffic stop, Trooper Longuski witnessed Mr. Conley crash into a secondary patrol vehicle and flee into the neighborhood on foot before subduing him with a single taser deployment. Mr. Conley was arrested and charged with third-degree fleeing and eluding and assaulting, resisting, or obstructing a police officer. On June 3rd, 2024, a formal preliminary examination was held before Judge Victoria Shackelford in the 23rd District Court. Defense Attorney Kendrick Riggins was representing Mr. Conley and District Attorney Omar Shazrad representing the state of Michigan.
Raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, sir, if you can have a seat, Trooper, and if you can start by saying your first and last name and then spelling your first and last name for the court recorder.
Cody Longuski, C-O-D-Y. Last name is L-O-N-G-U-S-K-I.
Okay, your witness.
And thank you, Judge. Good morning, sir. Can you please restate your name for the record?
Yes, Cody Longuski.
And how are you currently employed?
I'm a trooper with the Michigan State Police.
Okay, and how long have you been a trooper with the Michigan State Police?
It'll be 7 years tomorrow.
Okay, and are you assigned to any particular unit with that?
Just traffic.
Okay, and were you working in that capacity as a trooper on 5/2/2024?
Yes, sir. Was.
And did your duties take you to the location of Statler Street and Kenyon Street in the city of Taylor, County of Wayne?
Yes, sir.
And were you dispatched to this location at this time, or were you on routine patrol?
I was dispatched.
Okay, and what was the nature of that dispatch?
Our helicopter, Trooper 3, was following a vehicle that had just fled from Detroit police, which brought that car ended up driving all the way down into Taylor.
Okay, and were you in Taylor at the time?
Yes, sir, I was.
Okay, and were you given a description of this vehicle?
Yes, it was a dark in color, black or possibly dark gray Challenger.
Okay, and while patrolling, did you ultimately locate that vehicle?
Yes, sir.
Okay, and what, if anything, did you do?
At that point, he was coming towards me.
Who's he?
Sorry, the Challenger was
Okay.
coming towards me. Where I turned on my lights to effect a traffic stop on him, at which time he fled around my car.
Okay, and you indicated that the vehicle was coming towards you. Were you traveling on the opposite side of the road at that time?
It was a residential. He was coming, sorry, the car was going west into a curve, and I was going north into the curve as well.
Okay, and so did you have to make a turnaround?
I did, yes.
Okay, and at that point, did you initiate lights and sirens?
I initiated my lights before I made the turnaround.
Okay, and then you turned around, correct?
Yes, I did.
Okay, and then did you follow that car?
The car ended up crashing and I fell.
Okay,
It did what? Crashed where?
It crashed into the secondary trooper that was behind me.
okay, and so let me just stop you there. Were you able to turn your vehicle around first?
No.
Okay, so it got into the accident prior to?
Yes.
Okay, and when it was coming towards you, can you describe how that vehicle was operating?
At that time, it was driving around the posted speed limit. Once I activated my lights, I could hear the exhaust acceleration, where it accelerated around my car and then onto the wrong side of the road.
Okay, now when you say around your car, did it have to maneuver around your vehicle?
It went around. I don't know if it had to maneuver around. He had a route on his proper side of the road.
Okay, so how close did you get to the vehicle before you initiated lights and sirens?
Was probably, I would say, anywhere from 20 to 30 feet away from the car.
Okay, and you indicated that that vehicle got into a crash, correct?
Yes, sir.
Okay, and were you able to observe that crash?
In my mirror, yes.
Okay, how did it crash?
I saw Trooper LaForge's lights were on. Trooper LaForge went to his proper side of the roadway.
Your Honor, I'm going to object him testifying to anything that Trooper Ford's did.
Well, he's just talking about he's just talking about his observations. He's not gonna, if he starts talking about what Trooper LaForge actually did or saw, then he's just talking about what he saw.
I saw Trooper LaForge go to his side of the road, and then I saw the vehicle crash into his front passenger side of this vehicle.
Okay, so were you and that Trooper LaForge driving together initially?
We were following each other, yes.
Okay, and were you able to observe Trooper LaForge initiate lights and sirens?
As just as lights were on, I don't believe the sirens were.
Okay, and then you indicated that there was a crash. Did you turn around to that crash?
Yes.
Okay, and what if anything happened when you got there?
After the crash, I observed the Challenger crash onto the front lawn of one of the residents there. And then I observed a black male wearing a white shirt flee from the driver's side of the vehicle.
Okay, and how close were you when you seen that individual?
Might have been 30, 40 feet away.
Okay, and do you see that individual in court today?
Yes, I do.
Can you please state where he's seated, an article of clothing that he's wearing?
Now, yes, he's sitting next to the defense attorney. He's wearing a green jumpsuit. I know, weird.
You're gonna let the record reflect the identification of the defendant in this case?
Record shall so reflect.
Now, as you observed the defendant exit the vehicle, did you pursue him at that point?
Yes, I did.
Okay, and was he responsive to you?
No.
And how so?
So I observed Trooper LaForge running on foot. I stayed in my patrol car with my lights activated. I tried cutting him off in front of him, but he continued to run. I got out, I heard Trooper LaForge giving many verbal
Yeah,
commands
Your
to
Honor,
stop.
I'm going to object to him testifying to what Trooper Ford
He's
says.
saying that's what he heard, Judge. It's not hearsay. This is what he heard. It's also an excited utterance.
Well, I mean, it could be maybe an excited utterance, but it's certainly, it's hearsay, whether there's an exception or not. Are you going to tell me are you going to testify as to what you did in response to hearing that?
Yes,
Then it's allowed for that limited purpose.
But Judge, with respect, it could also come in as an excited utterance. This is happening in live
Well,
time.
then you should set up a foundation for an excited utterance.
Okay, and so, Trooper, let me ask you this. Were you guys both pursuing this individual at the same time?
Your
yes.
Honor, again, I object to he can testify to what he says.
I know, but I mean, if he's trying to lay a factual basis or a foundational basis for an excited utterance, I mean, he's got to ask him some questions to lay that foundation. So I'm allowing it for that purpose only.
Were you running?
Yes, I was.
Did you observe Trooper LaForge running?
Yes.
And at that time, were you given any verbal commands?
I told him to stop or I was going to tase him.
Okay. And at that point, were you able to catch up to him?
Yes, I was.
And what, if anything, happened when you caught up to him?
When I caught up to him, I deployed my taser. I only got one probe into his back and then he fell to the ground.
Okay. And what, if anything, did you do at that point?
At that point, he was on his stomach. And then I just observed Trooper LaForge handcuff him without anything.
On direct examination, Trooper Longuski testifies that when he activated his emergency lights to stop the defendant's Dodge Challenger in a Taylor residential neighborhood, the defendant accelerated heavily on the wrong side of the road, collided with Trooper LaForge's patrol car, and subsequently fled on foot before being subdued with a taser. Under Section 257.602A of the Michigan compiled laws, fleeing and eluding requires the prosecution to establish that a police officer who was in uniform, performing their lawful duties and operating a vehicle identified as a law enforcement vehicle, gave the defendant a visual or audible signal to stop their motor vehicle. The defendant willfully refused to obey by increasing their speed, slamming the accelerator, or otherwise attempting to flee or elude the officer. The violation took place in a residential area and ultimately resulted in a vehicular collision. Mr. Shazrad's initial line of questioning appeared to be structured to obtain testimony from Trooper Longuski supporting each of these elements, while securely establishing the identity of the defendant for the record. When Mr. Riggins raised a hearsay objection regarding Trooper Longuski's testimony about Trooper LaForge's concurrent verbal commands during the foot pursuit, the prosecution argued the statements were admissible as an exception to the hearsay rule. Under Rule 803-2 of the Michigan Rules of Evidence, an excited utterance requires the prosecution to establish that a startling event or condition occurred, specifically an active, fast-moving foot pursuit of a fleeing suspect. The statement was made while the declarant was under the stress of excitement caused by the event or condition. The prosecutor's subsequent line of questioning appeared to be structured to obtain testimony from Trooper Longuski, establishing the immediate, high-stress nature of the chase to lay the proper foundation for the court to allow the testimony.
You did not see my client commit a traffic infraction in Detroit, correct?
Correct.
You weren't involved in this case when Detroit.
No, sir.
You don't know what happened in Detroit, correct?
Correct.
All you know is that there was a helicopter chopper that was surveilling my client, correct?
Yes.
All right. And that chopper gave a general description of a car, correct?
Yes.
And the best you can say is that when you saw the car my client was in, it matched the description of the car that you were driven, right?
Correct.
This was at nighttime, correct?
Yes.
It was dark, correct?
Yes.
And you were on a public street, correct?
Yes, I was.
You were coming around the corner. You were on Kenyon Street?
Yes, sir.
Okay. And he was coming around the corner. So you were both on Kenyon Street, correct?
Yes.
And you were both driving towards each other, correct?
Yes.
Now, at the time that you were driving towards each other, it was dark, correct?
Correct.
Are there any streetlights on Kenyon Street?
Not that I remember.
Not a well-lit street, correct?
I'm sorry, say that
It's
again?
not a well-lit street, correct?
I don't believe so.
All right. You driving a traditional trooper car, correct?
Yes.
It's a dark in color car, correct?
Yes.
Do you have the newer headlights where they're flat towards the car? I mean, flat on the hood, or are they the raised ones?
I don't know how to answer. I don't know. I'm not a car guy. Sorry. It's a newer Charger.
That's
all I
fair.
know.
That's fair. So you're in a Charger, correct?
Yes.
My client is in a Challenger, correct?
Yes.
And it's a dark color car, right?
Yes.
And so you turn the corner and you suddenly put on your lights, correct?
Yes,
All right. And did you try to drive into my client's car to stop it?
no,
Okay. You did not turn your car in towards his front wheel to stop him?
no, I didn't.
Okay. And you sure about that?
Yes, sir.
All right. So after that, you say that he drove around you
Yes,
and he ran into your partner, correct?
yes,
And at that point, he got out the car,
yes,
all right, and you gave chase,
yes.
and you immediately jumped out your car. Is that your testimony?
Not immediately, no. I followed in my car for a little bit while Trooper Laporte was running.
So what direction was he going in when he got out the car?
So it was on, I believe it was Statler Street. He went south on Statler and then west on Kenyon Street towards Beach Daily.
Okay, and so he was going in the direction that your car was in? Is it
Yes,
that what you're saying?
I did turn my car around, yes.
So by then you had turned your car around?
Yes.
That's what you're saying. And so he got out and he ran.
Yes,
You got out your car and gave chase,
yes,
and you eventually tased him, correct?
yes, sir.
During cross-examination, Mr. Riggins elicited critical testimony from Trooper Longuski establishing that the officer did not personally witness the defendant commit any traffic infractions in Detroit. The officer had no direct involvement in or independent knowledge of the prior events in Detroit. The officer relied entirely on a general vehicle description broadcast by an overhead surveillance helicopter. The encounter occurred at night on Kenyon Street, a dark, unlit public road with no visible streetlights. The officer suddenly activated his emergency overhead lights only after both vehicles turned a corner and were driving directly toward one another in the dark. This targeted line of questioning directly challenges the constitutional validity of the initial investigatory stop, specifically focusing on the absence of reasonable articulable suspicion under the Fourth Amendment in Article 1, Section 11 of the Michigan Constitution. To lawfully initiate an investigatory traffic stop, the law requires more than an unparticularized hunch. The officer must possess a particularized and objective basis connecting the specific vehicle to suspected criminal behavior. As established in landmark Fourth Amendment and Michigan jurisprudence, a generalized vehicle description, standing alone and observed under poor visibility conditions, is legally insufficient to justify an investigative seizure on a public roadway. By establishing that Trooper Longuski possessed no personal knowledge of prior unlawful driving, that the environment was pitch black, and that the emergency lights were activated suddenly upon clearing a corner, the defense undermined the operational reliability of the officer's identification. Absent a distinct, safe verification that the defendant's vehicle was the precise target tracked by the helicopter, the officer's immediate action to block or signal the vehicle to stop constitutes an unlawful investigative detention lacking the requisite reasonable suspicion.
Yeah, I'm going to throw out this question this time.
Okay.
Judge, the people move for bind over on all counts and reserve argument forever. We also move for bind over on the 2 additional counts, as stated in the.
And we're going to object to bind over. I believe the officer testified that he was not aware of anything that happened in Detroit. All he's aware of when he got on Kenyon Street, he was coming around one corner. He saw a car that matched the description of my client's car. He put on the lights and siren and he turned in it. They were driving towards each other. He didn't show that my client knew that this car was after him. All he showed that here was a car that was coming towards him, and then another car turned towards him. It is a natural reflex to get out the way when someone is driving a car towards you, and that's all that we have here, Your Honor. As far as the additional charges, I don't think we have anything that shows that this officer gave him a command. I think the officer even testified that once he caught up with him, my client was on the ground and was placing him in handcuffs. There's nothing that showed that he resisted anything towards that empty officer. All we have is this officer testifying that he gave a command and allegedly my client did not comply with that command. So, Your Honor, we object to the bind over. We object specifically to the additional charges, and we object to the police officer cleaning charge.
In his closing argument, Mr. Riggins systematically challenged the essential elements of the offenses, alleging that the prosecution failed to meet its burden to establish probable cause for a bindover. Regarding the count of fleeing and eluding under Michigan Compiled Laws 257.602A, the defense highlighted the trooper's testimony that the patrol vehicle and the defendant's car were traveling directly toward one another on Kenyon Street. Mr. Riggins argued that the defendant's sudden change of direction was an instinctive defensive reflex to avoid an imminent head-on collision in the dark, risk, which completely negates the statutory requirement of a willful or intentional attempt to elude a lawful police signal. Furthermore, the defense contested the 2 additional counts of resisting and obstructing a police officer under Michigan compiled laws 750.81d. Mr. Riggins emphasized the trooper's own admission that the defendant was already prone on the ground by the time the trooper caught up to him to apply handcuffs. The defense noted that, apart from the trooper's bare assertion that the defendant failed to comply with an unspecified initial command, the prosecution presented no evidence of physical force, threat of force, or active physical interference to support a bindover on those charges.
Judge, with respect to defense counsel's argument, Judge, if this vehicle is being stopped in the first place, it's because this officer, Judge, that testified today was given dispatch that this vehicle specifically was fleeing and there was a helicopter that was following it. Judge, that's the reason for the stop. He also indicated as he made contact with the vehicle and observed that vehicle, he initiated lights, sirens. Yes, he was coming at a direct angle towards him, but he also indicated that the vehicle drove around him and accelerated. How do we know that he accelerated? Because he indicated that he hears the exhaust. Now, Judge, as it pertains to the R&O, this vehicle ultimately crashes into the other trooper's vehicle. And we know this because the officer testifies to making this observation. Not only does he flee from the vehicle, but both officers pursue him, Judge. It takes a taser to ultimately apprehend him, to which point both pursue him and apprehend him and put cuffs on him, Judge. So I think we've met the elements of the crime pertaining to the fleeing on both officers as well as resisting and obstructing, because we know that both officers made those verbal commands and he wasn't compliant with any of those at that time.
You don't have to respond to that.
So, Judge, we believe we met a verdict. We move for bindo.
Okay. All right, look. As to count 1 and count 2, I do believe this is a probable cause standard. It's the lowest possible standard in criminal law other than reasonable suspicion. It's a low standard for probable cause hearing that I'm here to determine today. I have to find that there is some evidence to support these allegations on each and every element of the offense. The officer testified that he had his lights and siren on. He was in a fully marked squad car. I understand that the lighting might not have been that well, but anyone who's lives in this country knows what police lights look like. And the officer testified he heard the vehicle accelerating once he had initiated his lights and siren. He also indicated that after the vehicle was stopped or crashed into the other car, that he identified Mr. Conley as the individual who exited that vehicle. A foot chase pursued, and he gave lawful commands, including the command that he was going to use his taser if Mr. Conley did not stop the vehicle, stop the foot chase. And ultimately, the officer testified that he had to execute that taser to get compliance from Mr. Conley. So given all of that, I do find a probable cause standard on count 1 and count 2 that the people have met their burden and the defendant will be found over as charged. As to the other officers not necessarily needed for a preliminary exam to get a bind over on those charges, but there has to be evidence that comes in that's admissible, and without a basis or an establishment being set for an excited utterance or some other present sense impression or some other hearsay exception that would allow that statement to come in, and the people did not satisfy that burden with respect to the lawful commands. And given all of that, I mean, it might be fairly obvious that that would have occurred, but I'm not here to make determinations on what seems obvious. I'm here to listen to the evidence and make a decision based on that. So there will be no additional counts, but the defendant will be bound over to the Wayne County Circuit Court for all future proceedings.
Judge Shackelford determined that there was probable cause for counts 1 and 2, which included the fleeing and eluding and resisting and obstructing charges, and bound Mr. Conley. She concluded that the prosecution had successfully met the low evidentiary standard through the testimony of troopers' account of the vehicle fleeing his lights and sirens, the subsequent crash into a state trooper's vehicle, and the foot pursuit that ultimately required a taser deployment to gain compliance. However, the court declined to bind over any additional counts involving the second trooper, concluding that the prosecution had failed to establish the burden of proof to admit that non-testifying troopers' out-of-court verbal commands into evidence. As a result, the motion for additional charges was denied, and only counts 1 and 2 were advanced to the circuit court for future proceedings. These hearings underscore why an officer's absolute truthfulness under oath is the ultimate safeguard in our justice system. Whether a citizen faces an immediate loss of liberty through a warrantless arrest or deprivation of property via a non-consent tow, the state's initial action rests almost entirely on a single officer's word. Because that word carries such immense legal weight, these proceedings serve as the first critical crucible to test the accuracy and candor of law enforcement testimony against direct judicial scrutiny. Ensuring absolute honesty under oath protects due process, holding police discretion to a transparent standard, and ensuring the system's power to punish remains legitimate. Comment below if there is a case that you would like us to cover. Thank you for watching, and don't forget to subscribe to see more case analysis.